Next, this is a big issue, comes up a lot, fee splitting. But the fact is, it's actually a non-issue. It's brought up, but it's really a non-issue. And this is why. Let's start with the basics. We know that traditionally lawyers cannot split fees with non-lawyers. And the issue is really only relevant here in the context of law firm funding, right? When the law firm gets the money and then has to repay it from the proceeds of a case or a portfolio of cases. When a law firm receives funding from a litigation finance company, repayment typically comes from the proceeds of these cases. And some practitioners and scholars have raised the issue, well, is that fee splitting? Okay, I'm going to answer that. Let's first talk about the public policy against fee splitting, which is rooted in preventing the unauthorized practice of law and the control of case by non-lawyers. But we've already talked about control, right? Just because you provide money does not mean you can control it. In fact, prohibition is very strict on that. Fee splitting is a nuanced area of law and actually would warrant a lecture of its own. However, what can be said is that there has been a liberalization on this issue. There's certainly a trend. So first, I will tell you that the term fee splitting is not actually defined. And Professor Seebach of the Cardozo Law School has a really good article. It's actually really heavy. And I say that as someone who really likes to read heavy text. It's really a very dense article, but it's very informative, very well written. And I encourage you to go read that. Second, there is a recognition across the board that future earned fees are an asset subject to collateralization. And that muddies the concept of fee splitting. It's a future asset and banks collateralize that, right? If you're a law firm and you go get a loan, they're going to look at your cases and they're going to look at how much money you made and they're going to think how much money you're going to make and they're going to collateralize that revenue. Third, there has been a marked trend to recognize that litigation finance is not fee splitting because it is a financing vehicle from the future asset that consists of expected proceeds from cases. California notably is there, is on that trend leading the way. Fourth, some jurisdictions have outright done away with the prohibition, looking at you, Arizona. So there's kind of a sense that we can be moving away from this issue because there's other safeguards and the profession is very clear about control and duty of loyalty.